All right, so like I said, we have a ton of questions. I'm just going to go ahead and choose who to answer it. And then if others want to jump in, please do. Is this not working? We've got 4 mics, so we should be good. So Judge Liu, where do the participants for AOT come from? It should be on. Is it?
Okay. They come from lots of places. I think I said during my presentation, we get referrals from family, the MOST team, the detention center. We really try to get private hospitals to refer to us. They are probably the toughest customer. My AOT supervisor goes out to talk to them all the time, remind them about our program, and I think only the state hospital sends us people, unfortunately. So I really wish the private hospitals would interact with us more. We do try to remind them we are a service and we're here. I get petitions filed by parents and family members can file petitions on their loved ones for a mental health crisis hold. And so if they don't qualify for a hold, I will give them the AOT information. And so that's sometimes how we get the word out. So they come from many sources in the community. I would say public defenders are a big advocate and partner for us, actually. So we get a majority of referrals from public defenders, both on a criminal matter or even a civil commitment. So that's where the variety that we've seen.
Thank you. Does anybody else want to chime in?
Is that okay?
Yeah.
Okay, so in Iowa, we were having the same problem with our local private hospitals not referring as many people as we know really do need AOT. So we recently changed our procedure so that if somebody's already on an outpatient civil commitment and they deteriorate and they have to have their order revoked and they go pull and get into the hospital instead, all the people where that's happening are now going through a review to see an assessment to see if they are appropriate and meet criteria to come in, and that's already generated a lot more referrals.
Well, add one thing about freestanding psychiatric hospitals. They often don't know the court processes. They are often new to the community, and so one really good opportunity for a AOT monitor or somebody's involved on the team is to go out and train them on the processes, pink slipping and inpatient civil commitment processes, and help them understand how AOT works. They really do become a good partner, but they need education. Is
there a population of people AOT may not be good for? And I'm going to answer this first. And that is people with personality disorders, primarily borderline personality, or even more broadly, anybody who wants to be in the hospital. I've had clients meet me with their suitcases in hand to go to the doctor, to go to the psychiatrist, and those are not good candidates. Who else has an answer?
I guess I have an answer and a non-answer, which is folks who suffer from co-occurring substance use disorder make the psychiatric treatment received through AOT more challenging. I know that some counties might have exclusionary criteria and not include folks who have co-occurring substance use disorders. I would argue on the side of using AOT even if there is a co-occurring substance use disorder, because the AOT piece can be highly effective in treating the underlying psychiatric illness in hopes that we keep the brain fresh and we ultimately have better success in treating the substance use disorder down the road. So I would advocate that while those folks are more challenging, we need to include them in AOT.
I can add another. TAC recommends people with significant intellectual or developmental disabilities not be placed on AOT orders. If they are able to understand that they're being court ordered, then certainly they could be possibly a good candidate for AOT, but it's really important that the person understands what we're asking of them under the order.
So I just wanted to pipe in and say that the population that this doesn't work for well is people who aren't stable yet. So that's one of the things to keep in mind, is that we really do want people to be stable when they enter AOT so that they can succeed. It doesn't mean that it's impossible for somebody to succeed, but that's something that is increasingly an issue when you see people being discharged in an unstable condition with the idea that they're supposed to be able to continue stabilizing in the community. Sometimes that is possible, but it is a challenge.
Anybody else? We're good? Okay. How do you mitigate the possibility of judges ordering changes to the treatment plan that do not align with the treatment team's recommendation? Judge Winnell.
Judge. There we go. All right. Let's have Judge Stormberg answer this one. No, I'm just kidding. So it's a difficult question, and I know that we have a lot of questions in there, so I will try to give you the condensed version. So the question was, how do you mitigate? Well, first of all, I think this is not a generic empty phrase, but programs are going to be very successful when there's true collaboration. When the teams are meeting, when they're discussing issues, when judges are listening, when everyone on the treatment team is listening. There's been many times when I've had to tell our treatment providers, here's kind of the role I have to play under the statute. And so there's education going back and forth. So number one, and it's not an empty term, is collaboration. To be a little bit more specific though, there's an interplay, and I'm a big separation of powers individual. When all three branches of government understand when it's appropriate to exercise their authority over the other two, and when it's appropriate to submit to the authority of the other two. And so take the state hospital example, at least in Kansas, while they're there, while they're treating, the executive branch, the state hospital, has the authority by law to discharge someone that they feel like is stabilized and ready to go. When they're on the outpatient treatment order, we've shifted to the judicial branch, and then it becomes the judge's decision, and that judge has to make that decision. You'll see a lot of literature and suggestions on specialty courts that relate to judges can absolutely have staffing, can listen to suggestions, but they can't delegate the decision on a judicial function. On a treatment plan, my hope would be that in collaboration, the judge would understand that the treatment plan specifics is not something that we're qualified to render. We may love the long-acting injection, and we may really want a particular medication. We can absolutely discuss it. We can absolutely say, have we talked about this? What's going on? We can encourage. But my suggestion to any judge that would be that they do not render a treatment-specific plan, that they render an order for treatment compliance. And then there's a forum, if there's an objection to the treatment plan, to discuss it. But ultimately, I think through collaboration, hopefully the judge would understand what specific treatment is not a judicial function.
I gave you the question, so you have to read it.
Okay, well, I was also just wanting to add a little something to this one. So I'm a lawyer, not a judge, but I totally understand the frustration of clinicians when judges or lawyers try to be doctors. I just want to put into the air that as a lawyer, I will sometimes see psychiatrists, particularly older psychiatrists, using way out-of-date terms, just using like stereotypes and just like things that are way disproven and all. And so I think the best collaboration is when everyone is very respectful of the social worker in the room. And that's kind of a good like touch point to go to. So the question is, are mental health and recovery boards, so I'm assuming like a state public entity, files motions to terminate commitments on any AOT participant who is non-compliant with the orders, citing, "It opens us up to liability if we keep them under commitment." Thoughts? I do have thoughts. So I'm from Georgia. In terms of the liability on the provider from an individual being non-compliant from a civil outpatient commitment, there's not even really liability on the individual from that court order, much less. I mean, I'm trying to think of the legal argument where the provider and like who they would end up in trouble with. And generally, I'm with the state agency, but I work very closely with all our community providers. And it's challenging for individuals to find a lawyer to sue a mental health provider, particularly when they're, the individuals who end up in AOT have long records. I'm listed on the Georgia State Bar site as like a lawyer in behavioral health, so I get a lot of calls. I'm trying to sue the Department of Behavioral Health. No lawyer will take my case. Can you take my case? And I cannot sue my company, but I really just feel like liability concerns are overblown a lot of the time. And that, another thing is we often say for clinicians, if you do, make the choice that you feel comfortable defending on the stand if it comes to it. And that's usually going to be what you think helped the person and kind of what's in your heart.
So I have something to add to that as well, because I would be willing to bet that I can identify who submitted that question and where they were from. So what I will say about that is that it's sort of analogous to the argument that is often raised about why information can't be released under HIPAA. That isn't real most of the time. There usually are exceptions that apply, but they aren't mandatory. So what you will find in terms of how programs implement different laws is that they will find a reason to implement in the way that they think they should implement. There is an argument that you really do want to have strong state oversight of programs so that a program in one part of the state means the same thing that it means in another part of the state. There's always going to be a challenge, and there's always going to be tension between local control and state level control. But it's one of the things that we are going to be doing to try to promote a more uniform implementation of what AOT is, what does it mean, what is it and what isn't it. Is actually a tool that is going to be on our next panel. So I'm just going to encourage everyone to really tune in. If you're interested in this issue, tune in to the next panel, because we're going to be talking about the establishment of standards, which is challenging and difficult, but it is the thing that I think is the key to addressing these kind of decisions not to implement things in the way that the law is written, or choices to believe that you can't do something because you don't really want to believe that you have to do it that way.
And just one addition to that is some state statutes do clearly provide immunity from liability.
All right. This one is, I just lost it, so I'm going to paraphrase. The graduates in the video that we saw yesterday were pretty high functioning. So if you have people on AOT that aren't reaching that level of functioning, should they stay on AOT? And I'm going to ask Mark to answer that.
Yes, they should stay on AOT.
Thank you.
No, I think there are some patients who are superstars, who are incredibly bright, and their baseline level of function is higher than mine and yours, and they're going to do really well if they're effectively treated. And there are other people who are more average, or even maybe slightly below average, but they have potential to be productive citizens in our community and could benefit from AOT. So I know how hard it must have been to put that video together, because I've been advocating AOT for decades. And I've seen successes, but I haven't seen very many people who look as good as those on the video. But it doesn't mean that we don't have good outcomes from AOT for people whose whose best level of function is not as high as these folks.
Can I add something to that very briefly, Amy? And I'm going to choose my words carefully because Caleb chose to tell you his story, and that's his story to tell. And so I'm not going to add, as much as I would like to for this question, I'm not going to add a lot of other details that were outside of that because I don't have Caleb's permission to do that, and it was a closed court proceeding. But I would just let you know two things that he said, so I'm just reiterating in answer to the question, is that those were AOT graduates, and Caleb, he said, was on it for about 1.5 years. And so I would love to explain that more, but just want to give you some frame of reference for at least Caleb, because he was one of my graduates. He was a graduate of our program.
And I want to add, because I'm a parent of somebody who has not nearly achieved what those AOT graduates have, we still hold out hope. We still advocate fiercely to get them more of the right medications. But there are people in our audience today where I know that's also the case. And I want you to know that not only are we very strongly advocating to keep people on AOT forever if they need it, to stay out of the churn, to stay out of the prisons, to stay out of the jails, to keep them from being homeless. Not only are we advocating for that, but we're also advocating for also doing a much better job than we have for the past 60 years. For people who are not reaching that same level, we must provide the level of services that people like my son need.
And I think Dawn was the perfect example of that. She did not write a book, and she's not didn't talk about graduating college, but she was so proud of 2 years without being in the hospital, without being in the criminal justice system. And for our program, Dawn would be the norm, and the two gentlemen would be more the outliers. But Dawn is as successful or more successful than the other folks because she is achieving that same level of psychiatric stability, and that's what AOT is about. It's about achieving stability for each person as an individual, whether you write a book or whether you stay out of jail in the hospital for 2 years. Her pride in that was amazing, and I thought that was one of the best features of the entire video was her pride in that statement, and I think those are the folks we represent.
And I just want to jump in and say that, like, I talk about my sister a lot as a success story, and she is a success story, but she's also permanently disabled. She's not going to go to work. She's not going to get her own health insurance, and that is not a failure. She is doing amazingly well. She is stable, and she is happy, and she is living a rewarding life. And I do think that we always have to be careful that we are not only identifying people who are feeling good enough to come talk to 300 people as what you can expect from the program. The program is there so that everybody has the opportunity to live a good, meaningful life. And not everybody wants to face 300 people in order to say that.
And I'll add one more thing, and a lot has been said about the duration of the outpatient commitment order, and it's often recommended a year at least over 6 months. I will say that the program that I had oversight of, now this is not the norm, but there were a few, and one who has been on AOT for as long as 17 years. They just cannot maintain out in the community without that community supervision.
Not a failure. Not a failure. This is for Daniela in your former role. In a state where our office, by the way, Maryland, the Office of the Public Defender was against this program, what are tips for engaging them to facilitate smooth implementation?
So the first thing I would do is invite them to be part of the team and express their concerns. I think that as I was serving as a defense attorney, although I had all this passion for mental health and for the same population, I felt that I was at one side of the table and everybody else was on the other side of the table. And so really being brought into the conversation to hear my concerns and also ideas was really helpful for me to then have my own buy-in and be able to want to engage and contribute to the team. The other thing is invite the defense attorney, if possible, to go view a program. Until it's seen in action, I think sometimes the idea of what the program can be, or if my caseload is already too heavy, how am I going to add on more to my docket? Really, it is a game changer to see a program in action and connect that public defender or private attorney that's looking to serve as part of your AOT team to another lawyer. And it doesn't have to even be from your state. A lot of the questions that come up with attorneys are not necessarily related to how is this going to function with the legal requirements that I may need to carry out, but just lawyer to lawyer questions. And you know how it is. In any role you carry, if whether it's a judge to judge conversation, a lawyer to lawyer, social worker to social worker, sometimes being able to confide and say, I'm worried about this aspect, could you walk me through it? And if, even though I'm a prosecutor now, if there's any defense attorneys out there, public defenders or ad litems that are having reservations, I can always serve as a resource. And being on both sides of the table now, it really is just a matter of understanding that yes, your role is going to be important in this program, but you're sharing the responsibility with the group as well, which also takes that burden off of just one individual.
Thank you. David, Kentucky. There's a few rural areas in Kentucky. Is it possible to do AOT in those areas?
You betcha. We do have a largely rural state. We have a couple of cities, 2 cities really, Lexington and Louisville, but a lot of rural areas. The challenges are very different in rural areas because you have services that are more spread out across a larger geographic region. You many times have, of course, lower population, and that comes with lower funding for some of the services. So resources are stretched a little bit more thin. But the rural areas have the advantage because everybody knows everybody. And so you sometimes have the networks already established, and that makes it easier to go in and talk with everyone. And like Cindy said, everybody's related in Kentucky too. So, you know, talk to my cousin, third cousin down there and get things going. But yes, absolutely, it can be done in rural areas. And in some ways, it may actually even be easier because you have a really small county or town, and you can just go in and get everybody together much more quickly than you would be able to in a larger area.
Thank you. This is for Elizabeth. When's a good time to start your program evaluation process? Data collecting, that kind of thing.
Easy one, right when you're starting to implement and you're in the planning process. I think the program evaluation really should be part of implementation, whether it's, what I think of as small E evaluation or big E evaluation, like Dr. Gibson spoke of earlier this morning. That's more of the big E when you have researchers coming in, a lot of data access, resources for the analytics. But small E program evaluation can be just as valuable in both sustaining your program and just really helping to inform how the program is going and what improvements you could make. So really thinking about data collection evaluation from the get-go is important.
Thank you. And we're gonna, the next presentation, Jared's gonna talk about more systematic program evaluation beyond data collection. This is a softball for anybody who wants to take it, and that is, how do you celebrate the end of AOT? Not in the community, but for a person.
So you mean a graduation?
Call it that.
We do a graduation in our court. So everybody, the prosecutor, the defender, the AOT supervisor, we give that person kudos. Everyone gives that person a compliment. We give a certificate of completion in a frame, so it's a full-on graduation. I personally congratulate them, step down, and talk to them, and so we really, everybody in claps, even my bailiff, everybody claps for when they complete. It's a very joyous occasion. We allow, with permission of the participant, any family members they want to be there, so we make it a celebration.
I will tell you and suggest for the last year and a half, we've also started doing reunions. We do 2 a year in June and December, and a month before we invite every AOT graduate to come back and to just come have cake and hang out and see how things are going. So it's a suggestion and we're building it, but so far we've enjoyed it.
That sounds amazing. Anybody else? Oh, actually, I want Nick to answer, because I don't think you do.
So in Butler County in Ohio, when we have someone who's dismissed from AOT, we get the report from the doctor, and the court often dismisses the case prior to the person's next commitment hearing. So we don't have a formal graduation. I like the idea of that. I like the idea of reunions, but I do I get to know all the different AOT respondents quite well. And so I make it a point to make sure that they're notified by me personally, face-to-face or by a phone call. And I try to I congratulate them, but I always repeat at the end that it was their hard work that got them to the point of the AOT being dismissed, that it's their insight into treatment, that it's the work they did in treatment, and try to remind them the goal of the court is treatment, and they've achieved success in treatment.
And it'll be quick, but I want to add to that because we had that for a long time, and we had a lot of meetings with the providers, and now our provider reports say it's the recommendation that the case be dismissed at the next AOT hearing. And we've had conversations with all of our defense counsel, and so it's all this team collaboration that if they get that and the gap really is too far, they can reach out, we can figure it out. So, but that's the recommendation we get now, is to dismiss at the next AOT hearing, so we always have that final step with them.
And I would add, graduation is a wonderful thing. Just make sure that they have some kind of level of supervision in the community after graduation, a warm handoff to some kind of services.
That is absolutely critical. So when AOT ends, the only thing that should go away is the court order. The same level of supervision that kept them successful in the community at the end of the court order is not a time to decrease the level of service, because you're just setting someone up for failure. And this is for anybody who wants to answer. People who have AOT, do you serve people who are homeless in your programs? Cindy?
Sure. Yes, we do. As I mentioned earlier, they tend to struggle with success because if the hospital is discharging them to homelessness, we have a really hard time finding them and getting them into services to even work on housing with them. And so there's a lot of driving around looking for folks. But we do have some success stories. We had a lady who had been, she was from Atlanta. She had been homeless for 4.5 years, and she was standing outside of the library, wouldn't tell anybody her name. We got her in AOT. We worked on housing while she was in the hospital, and it turns out she had family in Atlanta who had kept her Social Security check in the bank for all of those years, which is unheard of in a world where folks steal other people's disability checks. And she lives in her own apartment and is doing very well. So there are success stories. There are people who do not want to be housed despite all of our well wishes for them. And some of those folks may not have a mental illness. They just don't want to conform to rules. So hope that answers that.
I'd like to add to it if that's possible. So our program is really new. It's only been up for like a year and a few months in Johnson County, Iowa. But our AOT program director has made it her mission to definitely stop that cycle of people being homeless. And so the first thing she does is if they don't have insurance, she gets them signed up for Medicaid. Then she can get a caseworker. Then the caseworker can help with finding the housing. We've had many people placed. And the other thing that we have that's really helpful is we have both homeless outreach from the police department, from the sheriff's office, our homeless shelter, and our community mental health provider. And they all collaborate to find the person.
Well, go ahead. Okay. I was really excited to brag about Georgia's supportive housing program, but it sounds like we lost a Georgia resident from Atlanta to Alabama recently. But so Georgia, as part of the DOJ settlement, has something called the Georgia Housing Voucher Program, which was an entirely state-funded permanent supportive housing rental subsidy program that also came along with something called bridge funding, which if your state can't support full-on, permanent rental subsidies, the bridge funding has been huge in terms of just allowing, it's a mechanism to throw, 3-digit to 4-digit dollar amounts at barriers to folks getting housing. And that has been really, I haven't gotten to see the transformation, but whenever I hear from other states, it's a huge difference in how housing is just not the issue that it is anywhere near the degree it is in other states.
Just a final comment. For our program in El Paso, we do have participants that are unhoused. And at first it was challenging because that was quite different for our program. It seemed like it was more difficult and unable to locate our participants, but the conversation came down to, are we going to try harder or are we going to give up? And so we really had to lean on our social workers, our case managers to do the heavy lifting with the support of the judge saying this is an initiative that we're going to take. We are going to make the extra efforts that we need to do in order to include these types of participants in our program. And because they're in our program for quite some time, the social workers are able to build that rapport to open those conversations and dialogue to see if housing is something that ultimately they may be interested in working towards, or if not, at least continuing to engage with the program.
Thank you. This is one thing I know that Betsy and I worked on a couple of years ago, but do any of your programs receive referrals from the Department of Corrections or people coming out of prison?
We just started working on that. Our Department for Behavioral Health works really closely with the Department of Corrections, and we have a reentry collaboration group. And so individuals coming out of the prisons who have complex behavioral health needs, which is typically individuals with serious mental illness, we meet with them and help them identify community-based services. And these are really multi-complex kinds of individuals, some of whom may have history of sexual violence, and so may still be under sex offender registry kinds of conditions as far as housing allowance and so forth. But we have actually just started educating this group about AOT as another alternative. And we have not actually had a referral yet from the Department of Corrections for a reentry into AOT, but we definitely believe we can develop the capacity for that.
So I'll just say that we surprisingly had a referral from someone who was getting paroled from a Department of Corrections, and we don't discriminate, so we took him in and as a participant, but it was a surprise to us. We weren't, we had no discussions with DOC, and then we got this referral, and this gentleman was on parole, and we said, we'll take him, because he basically was paroled without resources and actually just brought to the state hospital. And so we said, well, we'll take him.
How's it gone so far?
So this was a couple years ago, and he did pretty good on parole with us. He was very tough. He was, again, another severely mentally ill individual. But he did okay, and then, it was just a little bit of a rough road. But we were willing to work with him, and, he kind of made it through with us, kind of squeaked through. But did not go back to prison that I can. So we felt that was a success, right?
Success.
Right.
So I just want to jump in and point out that this is the reason why statutes for AOT are meant to exclude periods of incarceration and hospitalization, because you want people to be able to qualify. So the period of time that you want to look at about whether or not someone's going to succeed in the community should be when they were in the community. So this is something to keep in mind if you are going to go back and you're going to look at your statute. There's a reason why you want to exclude those periods from the look-back period, because people benefit from the additional support, but they have to qualify.
This is for Mark to start off, and then, and that is, should people on AOT be prioritized for services like assertive community treatment and other intensive services?
Yeah, it's a little bit of a tricky question. So I argued earlier that the group we're talking about, people who are appropriate for AOT, should kind of rise to the front of the line, and I do believe that. But I don't know about you, but some people try to play the system, and so I hear stories. I don't know if it's true, that people will make a case that somebody qualifies for AOT in order to get services they might not otherwise get so quickly, but they don't really need AOT. So I think if we really stay true to the criteria for AOT as we all understand it, then I would be fine with the idea of someone getting put to the front of the line, as long as people are not gaming the system and trying to get people on AOT for the wrong reasons. Anyone else want to weigh in?
So this issue comes up a lot when we're debating bills at legislatures, where people have concerns that people with AOT orders will jump the line, and that you'll end up with people who don't receive voluntary services, or don't receive services that they would otherwise be seeking as a result of this prioritization. And I understand that argument, and it does make sense that people would have that concern. What I will say is that the research really does kind of demonstrate that it has an overall lifting up effect on all services, voluntary and involuntary, when you invest in AOT. So overall, I think it's best not to really think of different populations as being in competition with one another. You overall want to improve the system, how it works for everyone. And if you're improving any part of it, and it improves all of it, even if it's just a matter of degree.
And agree, tricky question, just anytime you're talking about prioritization and, is early intervention to prevent someone from ever needing AOT a better use of resources than coming in on the back end? And just the importance of evaluation and data collection and paperwork that everyone who wants to just be out serving individuals hates is just so critical. I know Georgia had an unfunded mandate to do an AOT evaluation study, and we had to find almost $1 million to fund the 3-year study, just between the cushions. But we did, and it was definitely worth it, because I feel like a lot of the time what happens is it comes down to vibes. There's going to be a human being making the decision who comes into the program and who doesn't, and only by evaluating and kind of getting data can we move more towards evidence-based practices.
I think I'd like to add a point from an advocacy point of view. The amount of funding that goes to serve people with disabilities related to mental illness is woefully inadequate overall. And it should not be a zero-sum game where if we give this service to somebody, we're taking away service to someone else. And I know it's a reality that we've got limited resources, but we got to keep fighting that, because it's really shameful how little is given. If you look at the statistics of the percentage of disability associated with serious mental illness and compare that with the percentage of funding within our overall healthcare and human services dollars, we fall very short.
I want to add just one quick point. I know you're on time. But I really want to say that it isn't an either-or situation. People who are allowed to have AOT, they are healthier, they are using less resources overall. It allows more beds to be open. It allows a lot of other things to be open for those who can volunteer for the services. And these people have suffered long enough, so do we want them, the advocate in the room, to be first in line? Absolutely.
Anybody else want to chime in? I've been remiss, and I haven't introduced. All these folks have been talking at some point in this event, but y'all haven't been at all the sessions. You couldn't. So I'm gonna, you do know Judge Robert Winnell, because he spoke first day, but you wanna stand up and just. So again, these, yeah, stand up and exit, kind of like the whole Sound of Music thing. No. I have, no, what we're gonna do is I'm gonna introduce everybody, and then I'm gonna pose the $25,000 question, and I want everyone to answer it, okay? Because I'll get, I'm all ready, but yes. I know. So Daniela Chisholm, we've been working with her for 3 years. Amazing attorney, and who's worked both sides of the aisle. Is that right? Okay. Cindy Gibson, you all heard this morning. Just quickly about Cindy and her work with the data. That is gold standard data collection. And this is the only program out of 2 cohorts of SAMHSA grantees that I know that has collected that type of data. So thank you, Cindy. David Sussman, long history at the state hospital until they wrangled him to come work at the State Department of Behavioral Health. So thank you for your input. Nick Schranz. I've known Nick for, 10 years now, at least. And he's AOT monitor where I grew up, so. And he's been doing it for 18 years? 18 years. Mark Munitz, psychiatrist, you heard him this morning. He's been an invaluable resource for information and bouncing ideas off, and I can't say enough nice things about him. If you want to hear more, stop me and I'll let you know. Leslie Carpenter is our mom. Mindy, why aren't you up here? I just saw you. Anyway, is our mom an advocate, and she's been on NAOTIAC since it started in 2023. And then she joined TAC's staff, so I figured we ought to add another family member, so we added Mindy. Mindy, will you stand up, please? Mindy is a former legislator and, again, a mom and a lifelong advocate. Judge Liu, I got to meet Judge Liu when I first started at TAC. She's from the Washoe County, as you heard before, and she was a first cohort SAMHSA grantee. And because of her data, she was able to secure funding from the locality to continue to support their AOT program. Go data, yeah. Kate Schiller is an attorney, as she said. She's with Georgia DBHGD.
DBHGD is hard.
And I have, you're counsel for the department. Yes. But I have never met a more fierce advocate for the people we serve, which at the state level is really something. This is my good friend, Brooke. I have not known her since 2018, which is apparently what I said yesterday. I don't know what to say about Brooke. I could not function without Brooke. And this event is here primarily because of her hard work. So if you would all give her a round of applause. Elizabeth is another good friend. She was at TAC when I started in 2018. She really was in 2018, unlike Brooke. Yeah. Also a good friend, but has moved on and taken her research abilities to NASHBID, which is a weird way to say the National Association of State Mental Health Program Directors. It doesn't make any sense. Lisa Daly is our fearless leader, and so appreciate her support in this work.
And not Amy's good friend, I guess.
But I am a delight. Sarah Hyatt is our newest member of the team, but one of the most, my team, I just cannot say enough. I'd start crying if you made me talk about my team. I'm already getting a little choked up. They are the hardest working, the smartest people, and fiercer advocates for, again, the population we serve, I've never seen. Sarah's an attorney, and as you heard earlier, she oversaw the AOT program in Hamilton County, Ohio, which had how many people?
260.
260. So that's a lot of oversight. Betsy Johnson is somewhere. Betsy, could you stand up? Betsy's kind of retired, but we won't let her go entirely. She is the driver behind the first two symposia that we held, first in Ohio, then in San Antonio. These folks make this work possible. They really did a lot of hard work with regards to putting the program together and participating in the program. And I can't thank them all enough. But I am going to ask the $25,000 question, and that is, if you have an AOT participant who is non-adherent, what do you do?
Well, I personally wouldn't do anything, but I would give all the credit to the outpatient treatment team. So the first thing that I would do, I guess, as a monitor is have a conversation with the treatment team out in the community to see what all efforts have been made to help that person deal with whatever issue they're dealing with. And, you know, it can be something as minor as they're so disorganized that they have lost track of taking their medication. So, you know, case manager may go out and give them a pill caddy and help them keep track of their medication. Call them every day, see if they're taking the medication. You know, there's a variety of issues and scenarios that could have caused a person to have a little setback. It doesn't mean they need to be in the hospital yet. So all hands on deck out in the community first, and then if they show signs of psychiatric deterioration, then for sure get them to the hospital. As we all know, I think that every untreated psychiatric episode ends up with more brain damage, and we're trying to save them and keep them safe. So that would be probably the final result, unless they're at that stage. And if they're at that stage, they need to go to the hospital.
So what I would say is that AOT is a problem-solving court. So the first thing I would do is really figure out what is the reason why somebody is non-adherent. There are a lot of reasons why that might happen. Some of them can be logistical things, like Sarah was talking about, and some of them can be, addressed by just, additional contacts, outreach. You also have tools. Obviously, the judge has the ability to have somebody come to court and have a conversation about what's going on, what can we do that can provide you with the support that you need to succeed. A lot of statutes actually do have this kind of progression built into them, and we do recommend that so people know what to expect. But like I said, a problem-solving court, the first thing you do is try to figure out what is going wrong.
As a researcher and data person, I don't know if I'm qualified to answer this question, but I guess my easy sort of layperson answer would be to say to the respondent, I understand and I'm here to help you.
I would say use peers if you have access to them. I know that our friend Kim that we saw yesterday was not a fan of seeing a peer, but I think that connecting folks with others with lived experience and who also have experience going through the system themselves is really, really important, and that as much outreach as you can do, and yeah, if you have peers, use them.
So I know I'm a lawyer, literally like working out of an office building in Atlanta, and that's really far away from the individual who is non-adherent, but I'm close with the regional agency staff, trying to get close with the actual community providers. And I think so often from like my position or maybe even a court's position, it can feel like, things have gone way off the rails and no one knows why, and no one knows what needs to be done. But someone close to that individual probably does know exactly what is needed. And so kind of using relationships to find out who knows what they need, what is that thing they need, and then finding out at the state level how we can make more of that need fulfilled.
So as a judge, I really feel that I'm probably the least intelligent person among my staffings on a non-adherent client. So what I do is I really rely on my AOT supervisor and staff to tell me what's going on. We get, during our staffings, input from both the public defender, who knows their client very well as the prosecutor. I mean, we brainstorm together. And that person may not even be due in court that day, but we're just staffing that person to figure out a plan. What's the best plan for the person? What's the specific plan for the person, including maybe not coming to court? Because we know a lot of these individuals have traumatic experiences with court. So we really cater to what's going to be effective for that person, and I really rely on my team to give me that advice. And if it is, they need to come to court, you need to talk to them, I say, all right, let's do that. Let's schedule for the next hearing, and let's see what we can do. I really appreciated Dr. Amador's advice. I don't think I'll fully learn the LEAP language, but I'm going to try. So
Thank you for wanting to try. Amazing. As a family member in the room, I would be remiss if I didn't say, contact the collateral support system. See what the family might know about why the person isn't taking their medications. Families are with the person so much more than anybody else standing up here, and we may have that little piece of information that you don't know yet. And if they're complaining about side effects, listen to them and help them advocate in case that needs to cause a change. Oh.
So I will play the role of the medical director of a county, which is the role I was in. And after all of what's been described already has been done, and I endorse all these great ideas, eventually, if the person is clearly not adhering and is showing signs that they're beginning to go down that downward slope towards the decompensation, then the process I would use would be to hear from my counterpart, the medical director of the agency that's providing the service to this individual, saying it's time to request that the court send someone to pick the person up, ideally as a CIT-trained deputy or officer, to bring them to the psychiatric emergency service to be evaluated. Oftentimes, when that happens, more often than not, the evaluation will result in the individual deciding that they're going to get back on their treatment. If they're on an injectable, they'll take their injection in the emergency facility and they'll go back home and go from there. In the rare case where they're not willing to do that, then rehospitalization would be indicated.
And I'm going to agree with Dr. Munitz because we have similar programs in the same state. anosognosia is real, and despite all the attempts to engage families and the treatment team and peer supports and all the other ideas mentioned, we can engage and engage and engage, and some people choose to be disengaged. And following what Dr. Munitz said, our court allows me to file an affidavit summarizing the whole situation, the attempts made at treatment and all the different scenarios around that. I even have a crisis team go evaluate someone in the community first before filing an affidavit for hospitalization, just to see if they would be brought in by the crisis team. If all that fails, then because they are under court order, I'll file an affidavit with the court for the CIT trained sheriff's deputy at our crisis team to pick up the person. I make arrangements ahead with our hospital. On some occasions, as Dr. Munitz said, our respondents will accept their injection in the emergency room and go home. In other cases, they need a hospitalization, and then to protect their rights, the court order ordering them to the hospital is not a court order for medication over objection, and then there's a special hearing for that in the hospital setting for those occasions when someone doesn't choose to get the medicine voluntarily at the emergency room or on the inpatient unit. And that's the way we use the court order to help the people who need it the most and can't get it or aren't able to get it in the community because of anosognosia.
I agree with everything that's been said, but I'll just add an additional nuance. I'll put back on my clinical psychologist hat for a minute. And if I'm a clinician working with the individual, I would sit down. We would use Dr. Amador's listen, empathize, agree, partner approach, which is very effective. We would use motivational interviewing strategies. We would understand the stages of change. We would try to increase the perceived benefits of adherence. We would try to reduce the perceived barriers of non-adherence. And sometimes all that works beautifully. Sometimes it doesn't make any difference at all. But you certainly have to go through those different strategies and try to see if you can just engage the person in a conversation, and then you can go to all these other options that have already been enumerated.
Everything that they said, except we start with the Psychiatric Advance Directive. And so at Aftercare, they complete a document that tells us what they want us to do in that case. And we're going to pick the treatment team member who has the best connection and send them out with the team supervisor to have a conversation and see what's going on, and bring a copy of that advance directive with us, and then follow the rest.
Once more, agree with everything that was said, and again, just reiterating, finding out the why. Sometimes it's something very, very simple that can be cleared up quickly, or sometimes something more complex, but a quick staffing with all the parties is very critical. Leaning on the defense attorney, they have a good relationship with their client, and leaning on the rapport that the judge has with the participant to invite them in for a status, to check in, and if the participant is willing to share what is going on and how can we help them rather than how are we going to punish you, has been really helpful as well.
Great answers. I hope you all took notes. I have nothing to add.
Thank you. Thank you so much for all your hard work. I look forward to our continued work together, and see you a second Friday in April.